Thank you for listening to this episode of Listen Without Prejudice, our podcast in which we review Matthew Pennycook's 21st November 2024 statement. Since recording this episode, there's been a development in that we have the decision of the High Court in the Arctime Freeholders versus the Secretary of State case, which we do refer to during the course of this episode. It's not the whole mainstay of the podcast, but it does affect what might happen next in relation to the implementation of the Leasehold and Freehold Reform Act 2024. Having said that, at the time of recording this, the 5th of November 2025, we don't yet know whether there'll be a further appeal in that case. It's quite likely the story is going to run on, and our view is that that doesn't particularly affect what we say during the course of the rest of this episode. So do listen in and enjoy.
I'm sat here with Mark Chick, my partner in the Landlord Tenant team. We're here to discuss where we are, how we're getting on, what the government is doing in relation to the consultations that they were talking about nearly a year ago now. So we're looking at the legislative path of the potential amendments and changes to the legislation that they were looking to bring in for the changes to the leasehold sector. On the 21st of November 2024, there was a consultation. Well, there was a consultation announced by Matthew Pennycook as to what they were going to be doing and what the timetable for those changes were going to be. So I'm sat here with Mark, and we're just going to walk you through those. And
yeah, okay. Well, thank you, Chris. Let's have a bit of a chat about that. So yes, it's almost a year on. Obviously, I know when listeners will be listening to this, I'm not quite sure. But on the 21st of November last year, Matthew Pennycook, as Housing Minister, made a ministerial statement announcing a number of different changes. And obviously we've talked a lot in previous episodes about what will happen in the leasehold system, the reforms, specifically around enfranchisement. But it's quite perhaps worth, as we run up to the anniversary of that date, have a little look about what Mr. Pennycook said he would promise that he would do. There are about 8 promises of consultations. So I thought it might be helpful just to run through those. And the first one that you talked about was right to manage. And you may recall back in January, had the changes to the qualification criteria there. So now I've got the 50% rule. Also changing the position in relation to costs. So that was a promise that was made that's been delivered on. This in spring.
Made a substantial change, I think, because I've certainly seen a number of claims that have come through where the landlord has not been looking to do anything about it at all. In some respects, they haven't even responded, and they're just assuming that it's going through.
Well, I think now they can't get their costs, exactly that, and that's probably the intention within the legislation.
Yes.
The next promise was to then go out consultation, as you said back in November, very shortly on the question of buildings insurance. Now, obviously, we know that insurance and insurance commission is a big issue for flat owners, because within the service charge, they're required to reimburse the cost of insurance, but the landlord can, of course, earn the commission on insurance itself. And the plan is to ban that commission and replace it with an administration fee. And that consultation closed in February. So we're waiting the outcome of that, but that was another promise that's been delivered on. So there we are. So we wait and see, but there'll be some big shifts in the management space, which we'll come on to in a minute. The other promise was a consultation to look at service charges and legal costs. Now, you may recall within LAFRA, there's a few game-shifting provisions. Landlords particularly won't automatically be able to get their costs of taking a service charge budget into the first-tier tribunal. They'll have to apply for leave to get their costs in the same way at the minute that the tenant would have to apply to resist the landlord adding those costs to the budget. But there's also a lot of other stuff in there as well, quite a big consultation, and that's an open consultation at the moment that closes at the end of September.
Yes.
So by the time people are listening to that day may have passed. But yes, there's quite extensive consultation on that.
Just in case anybody wasn't clear, LAFRA is the Leasehold and Freehold Reform Act 2024 that was enacted on 24th of May 2024 last year, but has not yet fully been brought into force.
Absolutely, Chris. Thank you very much. That's a very important piece of context. So we're talking about changes to the major piece of legislation that's sitting there parked, if you like, and about to come into force. About to come to force. Some bits of it are about to come into force, subject to consultations. And that brings us nicely onto the next bit, really, which was the bit that we as the enfranchisement lawyers are most interested in, the capitalisation rate and the deferment rate. So the ministerial promise was that next summer, and this was bearing in mind that was a statement made in November, and now we've had the summer in 2025, they would consult on the rates to be used, the capitalisation rate and the deferment rate in the calculation, the enfranchisement calculation, and to switch on those valuation reforms within LAFRA, that consultation would have to take place. So both you and I, Chris, know, and we've had plenty of other discussions about this, and we've done other episodes on this, people are waiting to see what will happen.
Yeah.
And there is no news on that.
There is no news whatsoever. So our advice to clients has continued to be act as if the legislation is not changing at the moment, because it's very difficult to see with the challenges that are going through the courts at the moment when that is likely to be brought into force, isn't it?
Yeah.
There was a case not that... I think we're waiting for the decision on that case at the moment. Are we?
So we are. So we're waiting for the outcome of the judicial review.
Yeah.
Obviously, once we have that, where we will know, well, how that fell and whether the freeholders challenge to the basis of the legislation itself is successful.
Yes.
But what the government does after that, whether they win or lose, whichever side, there's a possibility of an appeal. So I think the short answer of that, because we have done another show on this, is wait and see.
Yeah.
But is that consultation going to take place? The answer is no. And in fact, there have been statements made in the House of Parliament, not ministerial statements, but answers to parliamentary questions, which have shown us that the governor said it's going to wait till the outcome of that case is known before launching that consultation. So it's very much a wait and see. So that's a job not done if we are marking Mr. Pennycook's homework, not that it's necessary opposition to do that. The next one, it was about looking at consumer protection and service charges. They might recall that estate management charges, as you and I both know, are not subject to the service charge legislation. I'm sure you've had many examples in practice, Chris, of people who object to paying these charges. They're subject to third-party payments. They're either levied by way of a rent charge, and whilst they go towards maintenance costs, there's no control over those. And so the LAFRA contains provisions that will bring those within the service charge legislation. So that in part is in the current service charge consultation, but obviously there's more to do in that direction as well. And Mr. Pennycook said in his statement that Law Commission's recommendations could have been more fully enacted. So I think there's some more work to do. And perhaps that's a good point in time to mention that we are probably also looking at a new bill at some point soon dealing with commonhold and possibly a few other things as well, which we will come on to.
Let's talk a little bit about the mixed tenure estates that we've been looking at and what that looks like in terms of the proposed reforms that have been put forward and whether or not they're going to be bringing an end to that. Because as you rightly said, the opportunity for people who own units within those sorts of estates to contribute towards service charges and the ongoing maintenance of those sorts of developments. And at the moment, as Mark correctly said, you have to deal with that by way of a rent charge over the property, which is what the government's looking to bring an end to and to bring that back within the service charge provisions.
Exactly. It's more to bring in, so to allow people whose payments are subject to such a form of rent charge, even though they've got a freehold property, to then take the question of that variable payment into the tribunal.
Yes.
In the same way you can with the service charge, which is currently a legal sort of lacuna. There's just a gap in that you're not able to do that at the moment. So obviously doing that would cure that ill. And there are further restrictions on creating rent charges for sort of no readily or good apparent reason. You can't create them just purely for income reasons anymore anyway.
Yeah. So it underlines a good reason as to why leasehold actually works quite well, doesn't it? So in those sorts of estates, what you used to see, and less so these days, is the houses that would be let on leases because it meant that they were subject to the service charge legislation.
Well, yeah. And that brings us on to another good point as well. So, of course, something that the previous administration looked at, and indeed we go back to the leasehold scandal, the 2017, 2018 work we've done on this, the ministerial statement made by Sajid Javid when he was the housing minister that they would ban leasehold houses. And here we are, more than 5 years later on, the government still no closer to banning leasehold houses. They say in the ministerial statement they would consult on the best approach to banning new leasehold flats. So LAFRA does contain provisions which will deal with preventing the use of leasehold tenure for houses, which to a certain extent might or might not cure some of these ills. But the next step, the big step, I suppose, really is to look at what will happen if we're going to replace leasehold with something else. And that, of course, that's something else, as we know, is commonhold. And another promise, it was that they would publish an ambitious draft leasehold and commonhold reform bill. Now, we've had the white paper consulting on that. That was published back in the spring of 2025. So obviously that's a promise that's been delivered on, but the actual legislation itself is currently awaited. And I guess the big question will be, what will that contain?
Yes.
So we'll
there's
wait
been
to
no
go to Brexit.
there's no draft white paper or anything setting out what the act's going to look like. So it'll be interesting because, of course, commonhold initially came onto the statute books in 2003.
Yeah, well, 2002 the Act, and then it came into force in 2003. It goes to 2004 actually. When in fact David Lammy was the housing minister. He signed it into force. There we are. And it's back in government again now. So there we are. So yeah.
Well, hopefully he'll be able to finish what he started.
Well, maybe we won't be the housing minister then. We've got the new housing minister, of course. So
you never know.
Yeah, well, it's the Secretary of State for Housing rather than the new housing minister. But I guess we hope that the current programme of reform does begin to see its way through. And we are, to be fair to the government, we've seen some progress in some directions here. I think the other thing to bring ourselves onto, I mean, we talked about commonhold and whether there'll be a bill. Obviously, we wait to hear about that. I think really there were some other promises here. One of the other ones, the big one being around reforming the service charge legislation. Yeah, there's the open consultation on that. That does deal with a lot of different points, which we won't go into now. No. But they're all consumer facing, and they're going to increase the burden for the industry in terms of how they have to comply with that. And then one of the last things that the ministerial statement said was that they're going to look at Lord Best's report from 2019 about the regulation of managing agents. Yes. And if we talk about management, go back to the point you just made, Chris, about what's going on with estate management charges, people's dissatisfaction generally. A lot of the negative press that we've seen recently, in the last 12 months or so of reporting, particularly post this ministerial statement, has been a lot of exposés of poor management practice, and rightly so. Come down to the fact that anybody can set themselves up as a managing agent. You or I, Chris, could do that now. We could go out of this room, we can set up a managing agent business. Okay, we happen to be solicitors as well, so we're highly regulated professionals. Perhaps we make a good job of it. You don't know. But we wouldn't, or if we didn't have any qualifications or experience, we could still do that. And that's just a little bit crazy, I think, in the 21st century.
Yeah, they certainly, I mean, there have been numerous attempts to try and regulate that market in the past, but it's never really gone anywhere. It would be good to see something happening to make it more regulated, because a lot of the concerns that you get from people more generally, and quite often the motivating factor between groups of tenants in, for example, buying the freehold or exercising the right to manage, is of course, clues in the name, because of the management of the block itself. Which perhaps is one of the reasons why LAFRA is being looked at, reform to the leasehold sector is being looked at, because management often is not very good. Because I think if people were living in a long leasehold property and the building was being well looked after, and they weren't being, there weren't as many questions over the charges that they were having to make, then perhaps they wouldn't be looking at this, and it wouldn't have meant that the government would be looking to change it in the way they are. That's not to say that I don't think it's a good thing. I think it is a good thing. But quite often the motivations for collective claims is due to poor management. Yeah, so we hope that we might hope that the consultation on regulation of managing agents does bear fruit. And lastly, then it comes back to the final point that in the ministerial statement was the consultation about private estate management charges, which have been called leasehold, rather politically sort of charged name. But obviously, if you're paying something you're not in control, but you may well feel you are being fleeced. So I do understand the logic within that. So yes, so we're sort of, I mean, there's been some progress. Obviously, the big ticket items, the leasehold enfranchisement items, are on hold. But on the management side, it looks like there's going to be some further progress. So that would be good. I had a call with some clients yesterday who were looking to instruct us, and their main concern was that they haven't been provided with accounts by their managing agent for 24 months. Yeah, which is just appalling. Well, that'll be some of the provisions in this act will go some way to dealing with that. So yeah, there we are. Okay, well, so I think that's a good, if we, so reasonable progress on the ministerial statement. It's watch this space as ever, but there we go. And were you to mark his homework? What do you think you'd give it? Well, it's a difficult one. 7 or 8 out of 7 out of 10, I suppose, because obviously that would depend on, that's a numerical basis. Well, there are sort of 8 promised consultations. Yeah. If you were looking at the ones that obviously would excite our clients more specifically, be the enfranchisement ones, we know they're more difficult to deliver on, but perhaps we need to wait and see. We need to get the commonhold and bill to find out what else is going to go in there, because there's some other favourites in there. There's a ministerial favourite around abolishing forfeiture, which I imagine will go into that bill as well. Yes. So there's some other things, and it might be possible that the government decides to use this legislation to do some tidying up of some of the other pieces as well. So, although LAFRA, as we know now, is not perfect, it might be that there are some other more sweeping changes. So it will be a case of watch this space. Yeah, they've been talking about abolishing forfeiture for quite a long time, which will affect how people go about demanding service charge and all the rest of it. So it'll be interesting to see what the impact of that is for the rest of the service charge regime and leasehold property more generally, I suppose. But it's interesting.
Yeah.
So there we go. 7 or 8 out of 10 for Matthew Pennycook. Thank you very much for your time, Mark. That was very interesting. Hopefully people have found that interesting to give us a whistle-stop tour of what the update on the consultations is.
Well, thank you for listening to that episode. And as we said at the beginning, things have changed slightly in that we have the outcome of the human rights appeal case at first instance in the Arctime Freeholders and Secretary of State case. So I suppose it's worth asking the question, does that actually make any difference to what we were discussing and to the implementation of LAFRA itself? And for those looking to extend their lease or buy their freehold, what should they do? Well, I think the short-term answer is that actually not much has changed. It's too early. We don't yet know whether there'll be an appeal yet. There's 21 days from the initial decision, and we need to know how that's going to play out and whether that's going to involve an appeal within the UK or whether indeed that's actually going to go outside of the UK to the European Court of Human Rights. All of that could elongate the timescale. That said, the government was successful in the first phase of implementation, so is it quite possible now that they are going to move ahead with the stated changes in LAFRA as they reflect on enfranchisement? Does that mean there'll be a consultation on the rates, the capitalisation rate and the deferment rate, 2 things that we refer to during the course of the episode? And that's something we just don't know right at this moment. So does this really change anything we've said so far? Ultimately, perhaps not. Too early to say, but it is going to play out over time. And I suppose the initial point being the government being successful at first instance means they've got a stronger mandate to move ahead with the changes to the leasehold system generally and to the changes that are set out within LAFRA itself. So stay tuned for further developments, and thank you for listening.
That's all for today's episode of Listen Without Prejudice. Whether you're navigating a property transaction, a corporate, commercial or family matter, we're here to guide you every step of the way. If you enjoyed the episode, don't forget to subscribe to stay up to date on future episodes, where we'll continue to explore the latest trends and changes across our core practice areas. Do you have a question or topics you'd like us to cover? Or do you want to reach one of our experts? Feel free to get in touch via LinkedIn or through our website, bishopandsewell.co.uk. Thanks again for tuning in. Be sure to join us in our next episode, where the conversation continues. Until then, take care.